Commenter is obviously expressing unease with this language, but what does copyright law actually say about this? So first, what is a derivative work? Copyright law defines a derivative work as a work based on or derived from one or more already existing works. So for music, think a remix, a new arrangement, or a translation, etc. Section 103 of 17 US Code, aka copyright law, states that the copyright in a derivative work extends only to the material contributed by the author of such work, as distinguished from the pre-existing material employed in the work, and does not imply any exclusive right in the pre-existing material. Landmark cases have further upheld that principle, like Capitol Records versus Naxos of America from 2004, in which the court reinforced that the copyright in a derivative work only protects those new elements added by the author and does not confer any ownership or rights in the underlying work itself. Ultimately concluding that a derivative work is not a defense to copyright infringement where there has been an unauthorized reproduction of the underlying work. Okay, but wait a minute, the Spotify situation is different because we did authorize the reproduction, the distribution, and the derivative works. So is that it? Are we done? Hell no. The license language does not give Spotify free rein to do as they please with our copyrighted material outside of the scope of the license, including when such material is underlying in a derivative work. In my professional opinion, while the language is legally ambiguous, their rights are limited to what the agreement actually permits, which is in line with how courts have historically interpreted copyright licenses. And as a reminder of what I said about Spotify terms in the last video, among other limitations, I do not interpret the language as allowing Spotify to train AI or sync your music without permission. So even if their contributions to a derivative work were found to be copyrightable, which I think is unlikely if they're just using platform tools to auto-generate remixes, Spotify would only theoretically have a copyright claim in the new elements, and any uses of such works would be limited the same way the original works were limited. AKA, they still need your permission to do most of the things you actually care about. Also, a very important piece of this, even though the license says royalty-free, understand that means they aren't paying for the license which you granted them freely when you uploaded content. When you enter into an agreement, typically you receive something in exchange for the grant of rights, usually money. Here you're just acknowledging that they don't owe you any consideration for this particular license. But, listen closely, that does not mean that they're excused from having to pay master and publishing royalties out that are required by law, including copyright law. So even though their language says they can create derivative works, in my opinion, that means those works are still bound by this limited license, which does not permit them to feed your work into an AI model or sync it without permission because they don't own the underlying copyright and because you didn't grant them those rights in the license.